Welcome to Disputes 180. This is 180 seconds of what you need to know from the world of litigation and investigations. Brought to you by the wonderful team here at Paul Hastings in London. We have a link below to lots of great content on what we're covering today. So let's waste none of your precious time. Let's dive straight in. This is Disputes 180. Today we're looking at the world of litigation funding. There's been disruption in this area in the past couple of years, sparked by a UK Supreme Court decision and uncertainty as to the government's response. We're currently waiting on a report from the Civil Justice Council, which is expected to make recommendations on the way forward. But how did we get here? To set the scene, in 2023, the Supreme Court handed down its decision in PACCAR, and it looked like we were in for a major shake-up of litigation funding. But we're nearly 2 years on, and the full impact remains unclear. As a reminder, the case involved a dispute over LFAs. These are contracts between claimants and third-party funders to finance the cost of a legal claim. Of course, the funders do so in exchange for a return on their investment. The key question was whether certain LFAs count as DBAs. The Supreme Court ruled in PACCAR that many of them did, and therefore the strict rules which apply to DBAs risk making them unenforceable. Back in 2023, many people were looking for urgent legal reform to fix the uncertainty created by the decision. This led to the then Conservative government introducing a bill which amended the definition of DBAs and explicitly excluded LFAs. But the bill didn't make it through Parliament ahead of the general election and has not been reintroduced. In the meantime, the Civil Justice Council initiated a review of the litigation funding market and in October 2024 began a consultation considering questions of regulation, funder returns and the role of the court. The deadline for submissions to the consultation has been extended from the end of January to early March 2025. But the Civil Justice Council has said this will not delay publication of their final report and recommendations, which is due in the summer of 2025. The government, for its part, has said it will wait to see the report before deciding how to deal with the fallout from the PACCAR ruling. Presumably, that includes considering whether to reintroduce the kind of legislation that was previously proposed. In the meantime, funders have looked to rewrite their contracts or find alternative ways to structure their deals. This has included adjustments to their funding models to focus on returns based on a percentage of the funding provided, rather than a percentage of the damages recovered. Hopefully this has clarified the current position for you, but look out for updates from us once the report is published and the government announces its response. And that's your 180 for today. If you want to join a live version, we host regular events at the Paul Hastings office here in London, including our 2 flagship series, Developments in Disputes and The Future of International Arbitration. To make sure you don't miss out on any of this great content, follow our Paul Hastings LinkedIn page. If you've enjoyed this edition of Disputes 180, why not look out for the next one? That way, you'll have done a full 360.